There is a rule sitting inside council tax law that most pensioners have never heard of, and it lets a local authority go straight into your bank account and stop you touching your own money. Not your wages, not a loan, your bank account, the one your state pension and your savings sit in. And the strange part is, it isn't hidden in the sense of being secret. It's published in the regulations, it's used by councils across England, Wales, every single week, and almost nobody ever explains it in plain English until the letter is already on the doormat. So today I want to walk you through exactly how this works, in the right order, because there's a lot of fear circulating online about councils and bank accounts, and a good deal of it is either exaggerated or simply wrong. What I want to give you instead is the genuine mechanism, step by step, so you know precisely what can happen, what can't, how far away the worst case sits from where most people find themselves, and what to do long before any of it gets close to your account. Here's why this matters if you're watching this in your 60s, 70s, or beyond. Council tax arrears are one of the most common debts pensioners carry, and it's rarely because someone refused to pay. It's usually a missed reminder during an illness, a bereavement that meant post went unopened for weeks, or confusion after a single-person discount or council tax reduction changed without anyone noticing. Once that unpaid bill reaches a magistrate's court, the council gains a genuine set of legal powers, and those powers are wider than most people assume. Knowing the sequence, and knowing exactly where the real protections sit inside it, is what keeps an ordinary missed payment from ever turning into something frightening. If this is useful so far, a like really helps the channel reach more people who need it. And let me know in the comments where you're watching from. I read them all. Right, let's start with the one thing the entire sequence depends on, because nothing that follows can happen without it. A council cannot simply decide to enforce a debt on its own authority. Before anything at all, it must apply to the magistrate's court for what's called a liability order. This is not a punishment, and it doesn't create a new debt. It's the court formally confirming one fact, that a named person owes a specific, unpaid council tax bill. By the time a council reaches this stage, you'll already have received a bill, at least one reminder, and a summons giving you a further chance to pay or query the amount. If you've paid in full, if you're on an agreed payment plan that's up to date, or if you're genuinely disputing the bill, this stage doesn't happen at all. The liability order is simply the legal green light that allows enforcement to begin, and it's the point where the council's toolbox opens up. Once that liability order exists, the council typically writes to you with a request for information about your circumstances before choosing which recovery method to use. And this is worth understanding, because it's often where people go wrong by ignoring the letter entirely. Councils have a genuine menu of options at this point, and this is where confusion sets in, because most online scare content jumps straight to the most alarming one and skips the ones that are actually used first. The tool used most often, particularly with pensioners, is called an attachment of benefits order. If you're receiving pension credit or certain other means-tested benefits such as income-based job seekers allowance, income-related employment and support allowance, income support, or universal credit, the council can ask the Department for Work and Pensions to deduct a fixed weekly amount directly from that payment and send it straight to them. The figure is set in the regulations, not chosen by the council, and it currently sits at a little over £4 a week. To put that in real terms, if a pensioner owed £600 in arrears, clearing it through this route alone, at that weekly rate, would take somewhere around 3 years. It's slow by design, precisely so it doesn't leave someone unable to manage day to day. Who this applies to: anyone receiving pension credit or one of the qualifying benefits with an unpaid liability order against them. Who it doesn't apply to: the basic or new state pension paid entirely on its own isn't one of the benefits this specific order can attach to. So if that's the whole of someone's income, and they're not also receiving pension credit, this particular route simply isn't available to the council. Now to the part that actually matches what people picture when they hear freeze a bank account, because this is the real mechanism, and it deserves to be explained precisely rather than left vague and frightening. It's called a third-party debt order, and it used to be known by the older name of a garnishee order. Here's genuinely how it works. Once a council already holds a court judgment confirming the debt against you, whether that's the council tax liability order itself or a separate county court judgment for something like an overpaid benefit or an unpaid care charge, it can apply to the court for permission to freeze money held by a third party on your behalf. Usually that third party is your bank or building society. If a judge grants the application, an interim order is sent to your bank, and the bank is legally required to freeze the specified amount that same day, even though the money remains yours until the case is finally settled. This is where the fear people have genuinely comes from, and I'm not going to pretend it never happens, because it does. But here's the honest catch that almost nobody mentions alongside the headline. This is a formal court process, not a phone call or an email from the council. You are notified in writing. A hearing date is set. You are entitled to attend that hearing, and you can use it to explain your circumstances, including whether the frozen money is needed for essential living costs, and the court has the power to reduce the amount, delay the order, or refuse it outright on that basis. Only the money that's physically sitting in the account on the day the order is served gets frozen. Your next pension payment, or anything else paid in afterwards, is entirely unaffected and yours to spend as normal. And a joint account, say one shared with a spouse, is protected from this process unless the underlying debt belongs to both account holders, not just one of you. None of that makes the process pleasant, and I wouldn't want to suggest it does. But it does make it far less like the version that circulates in scare content online, where a council supposedly empties an account overnight with zero warning, and much closer to what it actually is, a slow, visible, and genuinely challengeable legal process with a hearing built into it. If you're finding this helpful, subscribe and turn on the bell so you don't miss the next one. I cover this stuff in plain English, so you don't have to wade through 40 pages of gov.uk yourself. It's worth pausing here to separate this from something people often confuse it with, because the confusion itself is part of what makes this topic feel scarier than it is. Bailiffs, properly called enforcement agents, are a completely different route, and they deal with goods in your home, not money in your bank. A council can pass a debt to an enforcement agent after a liability order, and that agent can visit your home and in certain circumstances take goods to sell towards the debt. But an enforcement agent has no power whatsoever to access your bank account directly. Only a court, through a specific order like the one just described, can do that. If a letter arrives mentioning bailiffs, it is not the same process as a bank account freeze, and knowing that difference alone stops a lot of unnecessary panic. There's also a genuine safeguard sitting quietly inside all of this that rarely gets mentioned, and it's worth knowing it exists, even if you never need it. Most councils in England and Wales now operate what's called a vulnerable persons or exceptional circumstances policy, which instructs staff to pause standard enforcement where age, ill health, disability, bereavement, or financial hardship is a genuine factor. It isn't automatic. Nobody flags your account for you. But if you, or a family member on your behalf, contact the council and explain the circumstances clearly, most authorities are required by their own published policy to consider a different approach before pressing ahead with court action. This is one of the least advertised protections in the whole system, and it's precisely the sort of thing worth mentioning explicitly if you're ever in this position, rather than assuming the council already knows. There are two further steps in the sequence worth knowing about, mostly so you can see just how far away they sit from where the overwhelming majority of pensioners with a council tax bill ever find themselves. If the arrears reach £1,000 or more, and you own the property in question outright or with a mortgage, the council can apply to the county court for what's called a charging order. This registers the debt against the house itself, in a similar way to how a second mortgage sits alongside a first, without forcing an immediate sale. In practice, it simply means the debt is repaid when the house is eventually sold, or when the estate is settled after death, and the homeowner carries on living there exactly as before while that happens. A charging order also by law requires its own separate court hearing, so once again this is a step with notice and an opportunity to be heard, not something applied silently in the background. And if the total owed reaches £5,000 or more, which usually only happens after several years of unpaid arrears have been added together across more than one council tax year, the council can in theory petition for bankruptcy. This is genuinely rare in practice, treated by most councils as close to an absolute last resort, because pursuing bankruptcy costs the local authority both money and considerable time, court fees included, and the great majority would far rather agree an affordable repayment plan than go anywhere near that route. For context, reaching that £5,000 figure through council tax alone would typically mean several consecutive years of a full annual bill going entirely unpaid and unaddressed, which is a very different picture from a single missed installment or one difficult year. Here's the myth I want to properly put to rest, because it's the one doing the most quiet damage to people's peace of mind. The idea that a council can simply instruct your bank to hand over your state pension the moment a bill runs a week late, with no warning, no court, and no chance for you to explain yourself, isn't how any part of this genuinely works. Every single stage described here sits behind a court order of some kind. A summons comes before a liability order. A liability order comes before enforcement action of any kind. And a third-party debt order specifically brings its own separate court hearing where you personally are entitled to be heard before a judge. The real risk in all of this isn't a hidden power the council has been quietly sitting on. It's silence. It's what happens when a council tax letter gets placed in a drawer unopened, month after month, while the account quietly moves from reminder to summons to liability order, without anyone at the council ever hearing that there was a genuine difficulty behind the missed payment. Think about how long that sequence actually takes in practice. A missed installment typically triggers a reminder within a couple of weeks. If it stays unpaid, a second reminder or a final notice follows, at which point the full year's balance can become due in one go rather than by installments. Only after that does a summons arrive, giving a further window before the actual court date. Only at the court date, assuming the bill remains unpaid or unqueried, is a liability order made. And only after that does the council choose an enforcement route, then apply separately to a different court for anything touching a bank account. From a single missed direct debit to an actual account freeze is, realistically, a process stretching across many months, involving several separate letters, at least 2 different courts, and multiple genuine opportunities to simply pick up the phone. That length of time is itself a kind of protection, even though it rarely feels like one when the first reminder lands on the mat. So here's the action that actually matters, and it's a good deal simpler than the legal detail above might suggest. If you ever receive a council tax reminder or a summons, open it and respond within the same week, even if all you're able to say at that point is that you need to talk about a payment plan. Councils overwhelmingly would rather agree an affordable arrangement than absorb the cost of taking a case through court, and most will pause enforcement the moment a genuine conversation begins, particularly where a vulnerable person's policy applies, which most local authorities now have in place for exactly this kind of situation. Alongside that, it's worth checking 2 things that quietly prevent a lot of these situations from ever starting in the first place. First, make sure any single person discount or council tax reduction you're entitled to is actually applied, because a discount that lapsed unnoticed after a change in circumstances is one of the most common reasons a bill suddenly looks larger than expected. Second, if you're on a low income, Check whether you qualify for council tax reduction through your local authority's own scheme, since this is separate from pension credit and is often underclaimed simply because people assume they won't qualify without ever checking. If a liability order has already been made against you and you're worried about what comes next, ring your council's council tax team directly and simply ask which recovery route they're planning to use, because you are entitled to that information as a matter of course. And most council tax teams have a specific line for exactly this kind of query rather than the general switchboard. Ask, too, whether their vulnerable persons policy applies to your situation, since it's a genuine question you're entitled to raise directly rather than something you need to already know about in advance. And if things have already gone further than that, both Citizens Advice and the Free Service National Debt Line will sit down with you, look at the actual paperwork, line by line, and tell you exactly where you stand and precisely what to say if a hearing does take place. They can also help draft a letter to the council, setting out your circumstances in the way the vulnerable person's policy is designed to respond to. None of this needs to be faced alone, and none of it needs to be faced in silence, which is genuinely the one thing that makes it worse at every single stage. Let me draw the whole thing together, because it's a considerably longer sequence than the headline alone suggests. A council can only reach your bank account after a court has already formally confirmed that the debt exists, and then only after a further, entirely separate court process aimed specifically at that account, with its own hearing that you are entitled to attend. The tool most commonly used against pensioners is a small, fixed weekly deduction from certain means-tested benefits, not an account freeze at all. The account freeze itself is real, and it does happen, but it arrives as a court order with proper notice attached, not as a silent switch a council can flip on its own whenever it chooses. Bailiffs deal with goods in the home, not money in the bank, and a vulnerable persons policy sits behind almost every council in the country, ready to be invoked the moment someone actually asks. And every single stage of this sequence has an exit ramp built into it, a phone call, a payment plan, a piece of completely free advice, any one of which closes the whole process down long before it ever comes close to touching a bank account. If there's one single sentence to take away from all of this, it's that the danger here was never really the rule itself. Councils have always had some version of these powers, and used properly and proportionately, they exist to make sure council tax gets collected fairly across everyone in an area, including the vast majority who do pay on time. The actual danger is a letter going unanswered for long enough that a slow, visible, and challengeable legal process is allowed to run its full course simply because nobody on the receiving end realized early on that a 5-minute phone call could have stopped it in its tracks. Now, before I go, the usual and important word. I spent my working life in and around money and tax, but I'm not your personal financial or legal advisor, and nothing I've said today is personal advice for your own situation. Recovery policies genuinely differ between local authorities, and your own circumstances, including any vulnerability, illness, or hardship, can change what happens next and how quickly. So do treat everything here as the shape of the process rather than a forecast for your particular case. And for anything material, speak to Citizens Advice or a regulated advisor, both of which offer exactly this kind of help, entirely free of charge. Thanks for watching to the end. If you found this helpful, share it with someone in the family who'd benefit. These rules matter most to the people who never hear about them. And do check the official links in the description before you act on anything. See you in the next one.